On up. Yes. This is cause number 24 CCCR 1553, cases style of state of Texas versus Dwayne Albert Hickman. Mr. Hickman, that's your full name?
Yes, sir.
How you doing, Mr. Hickman?
Doing great. How about you?
I'm doing fine. Now, Mr. Hickman, you're represented by your attorney, Wright Kimler, and Mr. Williams is representing the state of Texas. Mr. Williams, I have before me a motion to dismiss the case against Mr. Dwayne Hickman. Is that correct?
That is correct, Your Honor. The state believes that the substantive ends of justice will not be served by the continued prosecution of this matter.
And Mr. Hickman, I just signed the dismissal. You'll be able to get a copy from our court coordinator. Once you get a copy, you're free to go, and you have a blessed day. Okay,
Yes, sir.
let's see. We ready on Brandon Honey?
Put your hands up there. Hello, sir. Okay. You have it.
Yeah, is it? Okay, this is cause number 25 CCCR 0291. Case is style the state of Texas versus Brandon Honey. Mr. Honey, is that your full name?
Yes, sir. Yes, sir.
Mr. Honey, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Honey, you may put your hand down. How are you doing, Mr. Honey? I'm doing fine. Thanks for asking, Mr. Honey. You're represented in your case by attorney Wright Kimler. And Mr. Kimler, do you waive a record in Mr. Honey's case?
Right. It appears we have a court reporter.
You would like it?
It's whatever, I would waive a record if the court requires.
No, I'm not. If you want to have a record, you have a
That's, I
record.
would waive.
Let me see, state is abandoned and enhancement paragraph.
He was the wrong one. Oh, hate me.
Okay. Now, Mr. Honey, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Brandon Honey, on or about July 16 of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated with alcohol concentration level 0.15 or more. State, are you abandoning the enhancement paragraph?
That is correct, John.
So, Mr. Honey, the state is abandoning the enhancement paragraph, and then what that means is, instead of being charged with a Class A misdemeanor DWI, you'll be charged with a lower or lesser Class B misdemeanor DWI. Do you understand?
Yes, sir.
Now, to the Class B misdemeanor offense of driving while intoxicated while you were operating a motor vehicle in a public place on July 16 of 2024, how do you plead? Guilty, not guilty, no contest?
Guilty.
Now, you're pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Okay, Mr. Honey, I also have before me on my tablet a document that is titled misdemeanor plea admonishment. This document is also labeled as State's Exhibit 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials on a line that's marked guilty. Did you place your initials on this document? On page 3 of this same document, there's a signature above the line that's titled defendant. Is this your signature?
Mm-hmm.
And on the next document, there's titled trial court certification of defendant's right of appeal. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yeah.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document on paper that's titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line inside the defendant?
Yes, sir.
Now, Mr. Honey, before you sign and initial these documents, did your attorney go over these documents with you?
Yes, sir.
Did you understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Honey, are you a citizen of the United States?
Yes, sir.
State, like the office states exhibit number one.
So tender, Your Honor.
Any objections?
No objection.
No objection. States exhibit number one will be admitted. Mr. Kimler, you have advised and counseled Mr. Honey. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Honey, your attorney, Mr. Kimler has advised and counseled you. Are you satisfied with his services?
Yes, sir.
Mr. Honey, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
We do, Your Honor.
And what's the agreement? Oh,
It should be on the paperwork.
I'm looking at it. If you need it, you can look at this here.
Thank you, Your Honor. There'll be 90 days probated over a 1-year period of time. It would be a $400 fine and 40 hours community service. Is that correct?
Yes, sir. I think they waived the enhancement.
Yes, sir.
Yeah.
That's what it's been like.
Yeah, I mentioned that.
Thank you, Judge.
Not bad enhancement.
Yes. What's the court cost? $392.
I mean, that's what the court of law can.
Yeah.
Give them time.
Okay, Mr. Honey, the state is offering that you serve 90 days in Jefferson County Jail, but you will not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 1 month. Excuse me, a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $400 plus court costs of $392. You'll be required to pay a DWI conviction fine fee of $100. You're required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. You also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you will be required to pay each month. In this case, is $164 a month. Will you be able to pay the $164 each month?
Yes, sir.
Okay, you'll also be required to perform 40 hours of community service, attend a completed DWI education class, have an alcohol assessment, and adhere to the other standard terms and conditions of this probation. Now, Mr. Honey, do you understand the state's offer?
Sir.
Do you think that the state's offer is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Honey, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Honey, you're gonna stand at the end of that table, follow the direction of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go and you have a blessed day. Elijah Lewis. Yes, this is. Let's see, Lewis.
If you give you-
Yeah, this is cause number
give you whichever you want.
24 CCCR 1624. Case is styled the state of Texas versus Elijah Lewis II. Mr. Lewis, is that your full name?
Yes, sir.
Mr. Lewis, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Lewis, you may put your hand down. How are you doing, Mr. Lewis?
All right.
You tired? Okay, well, we have to get you out of here, go get you some rest. Now, Mr. Lewis, you're represented by your attorney, Attorney Wright Kimler. Ms. Kimler, do you have a record of Mr. Lewis's case?
So,
And Mr. Lewis, I have before me a document that is titled information. This information is filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Elijah Lewis II, on or about January 12th of 2023, while you were in Jefferson County, Texas, that you committed a Class B misdemeanor offense of driving while intoxicated. Mr. Lewis, do you understand what you have been charged with? And to this charge, how do you plead guilty, not guilty, no contest? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty? Mr. Lewis, I also have before me a document that is titled misdemeanor plea admonishments. You recognize this document? This document is also labeled as State's Exhibit number 1 on page 2 of this document. Oh, that's just, he put his initials on the first line on page 2. And I think on page 3, he needs to sign.
Trying to get away scot-free, that's what.
this one right there. Oh. Not,
And on the next page, I think his signature's at the top. Okay. Now, Mr. Lewis, on page 2 of the same document, there's a set of initials on a line that is titled guilty. Did you place your initials on this document?
Yes.
On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signatures? And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. First box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand this statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document on paper that is titled discovery certification. You recognize this document? And is this your signature on the line that's titled defendant? Now, Mr. Lewis, before you sign and initial these documents, did your attorney go over these documents with you?
Yes.
And did you understand everything that your attorney went over?
Sure.
And is everything in these documents true and correct to the best of your knowledge? And Mr. Lewis, are you a citizen of the United States? State, like office states 1?
So tended, Your Honor.
Any objections?
no, but
No objection. State's Exhibit number 1 will be admitted. And Mr. Kimler, you advised and counseled Mr. Lewis, is there any evidence that he is mentally incompetent to stand trial? And Mr. Lewis, your attorney, Mr. Kimler has advised and counseled you. Are you satisfied with his representation? Has he provided full, effective, and competent legal representation? Mr. Lewis, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. Will also find that your plea and waivers are freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The essential terms are as follows, Your Honor. It will be 90 days probated over a 1-year period of time, a $300 fine, and 40 hours community service. Is that correct, Mr. Kimber?
yes. That correctly reflects the plea bargain.
Okay, what's the court cause?
Just, what's this one?
This is Mr. Lewis.
Hmm. What? Yeah.
Okay, Mr. Lewis, the state is offering that you serve 90 days in Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail because you'll be on probation for a period of 1 year. During the 1 year probationary period, you will be required to pay a fine of $300 plus court costs of $392. You'll be required to pay a DWI conviction fine fee of $100, probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. You also be required to pay Jefferson County DWI education an initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $155 a month. Will you be able to pay the $155 each month? You'll also be required to perform 40 hours of community service, attend a complete DWI education class, have an alcohol assessment, and adhere to the other standard terms and condition of this probation. Now, Mr. Lewis, Mr. Lewis, do you understand the state's offer? Do you think the state's offer in your case is fair and just? And do you accept the state's offer? Okay, Mr. Lewis, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Lewis, stand next to the bailiff, follow her directions. Once you're finished following her directions, you'll be free to go and you have a blessed day. Carrie Nails,
Nails,
It's fine, you have the jury list. We need to.
Yeah.
Say to save
They-
on time. So we
they
don't
have
to
that.
start at
I'll be fair.
3:30. I need to look at, but we need to look at the list.
yeah, she has,
More down, I'll be about 15, 20 minutes now.
Second. Thank you, ma'am.
okay. This is cause number 25 CCCR 1046. Case is style of state of Texas versus Carrie Anika Nails. Ms. Nails, is that your full name?
Yes.
Ms. Nails, would you please raise your right hand? Did you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Nails, you may put your hand down. How are you doing, Ms. Nails?
Okay.
That's good. Ms. Nails, you're represented in your case by your attorney, Ralph Kimbler. And Mr. Kimbler, do you waive a record in Ms. Nails' case?
So like,
Ms. Nails, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Carrie Anika Nails, on or about March 14th, 2025, while you were in Jefferson County, Texas, that you committed Class A misdemeanor offense, resisting arrest, search, or transportation. Mrs. Nails, do you understand what you have been charged with?
Yes.
And to this charge, how you plead? Guilty, not guilty, no contest.
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you are guilty? Ms. Nails, I also have before me on my computer tablet a document that is titled misdemeanor plea minus. This document is also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of this same document, there's a set of initials on the line next to boxes. Check guilty. Did you place your initials KN on this document? On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes.
And on the next document that's titled trial court certification of the defendant's right of appeal, do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
On the next, now at the top of this document, there are 2 boxes checked. First box says check states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
Second box says check states that you're waiving your right to appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
I also have another document that is titled Discovery Certification. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
Now, Ms. Nails, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes.
And did you understand everything that your attorney went over?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. Nails, are you a citizen of the United States?
Yes.
State, you like to offer State's Exhibit Number 1?
So tender, Your Honor.
Any objections? No objections. State's Exhibit Number 1 will be admitted. Mr. Kellerman, you advised that counsel, Ms. Nails, is there any evidence that she's currently mentally incompetent to stand trial?
no, I don't think so.
And Ms. Nails, your attorney, Mr. Kimmler, has advised and counseled you. Are you satisfied with his representation?
Yes.
Ms. Nails, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers was freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, Do we have a plea bargaining agreement?
We do, Your Honor.
And what is that agreement?
The essential term is as follows. It would be 5 days in the Jefferson County Jail, time served, time actually served, with all court costs and fees being taxed and retired. Is that correct, Mr. Kimler?
That, Your Honor, that correctly reflects the agreement the state now reached regarding Ms. Nails' case.
Okay, Ms. Nails, the state is offering that you serve 5 days in Jefferson County Jail, but you would not have to serve any more time in the Jefferson County Jail in this case because you've already served 5 days in the Jefferson County Jail. Therefore, you'll be given credit for the time that you have already served. The court costs in this case will be taxed and retired. It simply means that you would not be required to pay the court costs because the time that you spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Ms. Nails, do you understand the state's offer?
Yes,
Do you think that the state's offer in your case is fair and just?
yes,
And do you accept the state's offer?
yes.
Ms. Nails, I'll follow the plea bargaining agreement that you have entered into with the state. Ms. Nails, you're gonna stand next to the bailiff, follow her direction. Once you finish following her direction, you're free to go and you have a blessed day. Okay, go to be in recess. We have another?
Yeah.
Oh,
We got respect to do. We're gonna
Oh, okay, hold on.
bring the jurors in, setting a later time, 2 or 2:30 for them. to-
well, I mean, I didn't know y'all was gonna sit here and work out a deal right before jury selection.
I'm saying even before, respectfully, Your Honor, even
Perry Lee, okay. Harris. Okay, this is cause number 23 CCCR 1180, case of style of state of Texas versus Perry Lee Harrison. Mr. Harrison, is that your full name? Mr. Harrison, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Mr. Harrison, you may put your hand down. How are you doing, Mr. Harrison? You doing all right? Okay, Mr. Harrison, you're represented in your case by your attorney, Attorney Ralph Kimler. And Mr. Kimler, do you waive a record in Mr. Harrison's case?
So waived.
Mr. Harrison, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Perry Lee Harrison, on or about May 27 of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense, evading arrest detention. Mr. Harrison, do you understand what you've been charged with? Okay, to this charge, how do you plead? Guilty, not guilty, no contest. Now, are you pleading no contest freely and voluntarily? Well, I'm looking at the paperwork. The paperwork have your initials on the line that's titled, that says guilty. You put your initials PH on this document. Okay, so on the line that's titled guilty. Are you pleading guilty or are you pleading no contest? Now, you're pleading guilty freely and voluntarily. Okay, and are you pleading guilty because you are guilty? Okay, Mr. Harrison, I also have before me a document. Well, I have the same document, but on page 3, there's a signature above the line that's titled defendant. Is this your signature? On the next document that's titled trial court certification of defendant's right of appeal, you recognize this document. And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document on paper that is titled discovery certification. You recognize this document? And is this your signature on the line as title defendant? Now, Mr. Harrison, before you sign and initial these documents, did your attorney go over these documents with you? And did you understand everything that your attorney went over? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Harrison, are you a citizen of the United States? State, like the office states exhibit number 1.
So tendered, Your Honor.
Any objections?
No objection.
No objections, states exhibit number 1 will be admitted. And Mr. Kimmel, you advised and counseled Mr. Harrison. Is there any evidence that he's currently mentally incompetent to stand trial?
There's none, Your Honor.
And Mr. Harrison, your attorney, Mr. Kimmel has advised and counseled you. Are you satisfied with his services? Mr. Harrison, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
The essential term is as follows, Your Honor, it'd be 10 days, in the Jefferson County Jail, credit for 1 day, and the time is to be served on weekends. That
Well, no,
correct?
he's doing it 10 days straight.
Are you doing a 10 days
Yeah,
straight?
he's doing it straight.
When-
He's gonna present himself before 6 p.m. This Friday, March 20th, to the Jefferson County Jail to serve the sentence
Okay, it's, you say March 20th.
before 6 p.m.
On
That way you get credit for Friday.
what's the court cost?
277.
Okay, let me do this here. Do we have an affidavit on that? Okay, Mr. Harrison, the state is offering that you serve 10 days in the Jefferson County Jail. You will be given credit for the 1 day that you have already served. The court cost in this case is $277. Are you able to pay the $277 court cost? Okay, they happen to just fill out that they just fill out the first page of that affidavit. That's just the bottom portion that is finances.
Well, to expedite it, can the state will waive or will request that all tax, financial costs be, yes. be
Well,
retired by the
but
state.
it ain't taxed and retired, that's the problem. I mean, we can put that language in there, but it's not really the truth. I mean, we could do it this here way and it'll be,
Right, so the
Yes,
top,
yeah.
the top part, Your Honor,
the bottom part where it says it's financial stuff, he just, on both sides,
so
at the,
this part, okay.
that and the other side, yeah.
Just fill out.
Just fill that out so I can look at your finances, see if you Now, Mr. Harrison, I have before me a document that is titled Affidavit of Indigence. And do you recognize this document? And is everything on this document still true and correct to the best of your knowledge? Okay, Mr. Harrison, the court is going to find that you're indigent. Based on the finding of indigency, the court cost of $277 will be waived pursuant to Article 42.15 of the Texas Code of Criminal Procedure. That means that you won't have to pay it. Do you understand that? Okay, now, Mr. Harrison, your jail time is to begin at or before 6 p.m. on March 20th of 2026, which is this Friday coming. Do you understand? Now, do you understand the state's offer? And do you accept the state's offer? Okay, Mr. Harrison, I'll follow the plea bargaining agreement that you have made with the state. Mr. Harrison, you're gonna stand at the end of that counter, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you're free to go and you have a blessed day.
Each time.
Okay, be in recess. Okay, Mr. Tate, you're gonna walk up to that first row right there, go all the way down to the end, that first chair. And Miss, what's that?
Problem?
Yes, Ravalo. Gonna sit next to him. Miss Smith, you're gonna sit next to Miss Ravalo. Miss Broussard, you're gonna sit next to Miss Smith.
Clear?
Miss Durso,
Yes,
you're gonna sit next to Miss Broussard.
yes, sir, thank you. What? Seven, Albert?
Mr. Valier,
Yes, sir.
you're gonna sit next to Miss Durso. Mr. Mudd, you're sitting next to Mr. Valier. Mr. Alfred, you're gonna sit in that first chair. And Miss Mayfield, you're gonna sit next to Mr. Alfred. Miss Bowler,
Yes, sir.
you're gonna sit next to Miss Mayfield.
Maybe? Earlier, you know about it correctly, I know you said something. Your number is like, John?
Huddleston,
Yes.
you're gonna sit next to Miss Bovar.
Well. Even though it's not the same one?
Yes,
Okay.
Miss Dunn, you're gonna sit next to Miss Huddleton. Mr. Toy, you're gonna sit next to Miss Dunn. Another Duracell, Miss Duracell. You're gonna sit next to Mr. Toy, Mr. Toy. Miss Idleberg, you're gonna sit in that, go all the way down to the first chair. You're gonna sit next to oh, is this Miss Perez?
Yes.
Okay, you're gonna sit in that chair next to the one with the paper. And Miss Holt, Mr. Holt, you're gonna sit next to Miss Perez. Miss James, you're gonna sit next to Mr. Holt. Miss Pilgrim, you're gonna sit next to Mr. James, and Miss Pearson, you're gonna sit next to Miss Pilgrim. Okay. Okay. Okay, good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. And before we get started, I'd like to apologize for the wait, but we had some business being handled in court while you were out there. First of all, my name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come to court today to serve as a juror in a criminal case. A criminal case is what we call a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your most serious type of offenses, whereas your misdemeanor cases are normally referred to as your petty offense. Does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted. Now, felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have the first degree, well, you have the capital murder, first degree felony, second degree felony, third degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is the minimum of 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. Now, if a person is convicted of a third degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, we do not handle felony cases in this court. We have jurisdiction over misdemeanor cases. Now, misdemeanors are divided into three categories. We'll start at the top, work our way down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, if a person is convicted of a Class C misdemeanor, the range of punishment is fine only. They only could be given a fine that does not exceed $500. Now, Class C misdemeanors don't start in this court. They start in the JP court or the city court. They come to this court when a person is found guilty in one of those courts, and then they appeal their case. They'll get a whole new trial in this court. The range of punishment does not change. It's still the same. That is, it cannot be a fine that exceeds $500. Now, if a person is convicted of a Class B misdemeanor, and the range of punishment for a Class B misdemeanor, minimum 0 days to a maximum of 180 days, which is 6 months in the county jail, or a fine that does not exceed $2,000, or they can be given both such jail time and a fine. Now, a person, if they are convicted of a Class A misdemeanor, which is the highest misdemeanor, the range of punishment is minimum 0 days to maximum 365 days, which is a year in the county jail, or a fine that does not exceed $4,000, or they could be given both such fine and confinement. Now, you will be examined for inclusion on this misdemeanor criminal case. Our courtroom hours normally vary. They're normally from 9 to 5, 9 a.m. to 5 p.m. However, in this court, we have dockets in the morning, and a docket is just a list of cases. We have a trial docket, we have a pretrial conference docket, and we have an announcement docket. And so we have those cases in the morning, and sometimes, like today, those cases go over into the afternoon. And so we start our jury trials. We try to get the jury to come here at 1:30, but on today, the cases went beyond the anticipated normal time. Now, whether you are selected as a juror today or not, you're performing a significant service which only free people can perform. If you are selected, the case will be tried expeditiously, consistent with justice, which require a careful and correct trial. Now, if selected, unless otherwise, you will be permitted to separate yourself for recess, for meals, and at night. Now, at this time, I must administer to you one of two administrative functions. That is, I must give you an oath. So I need each and every one of you to raise your right hand, and then once I finish administering the oath to you, please say, "I do." Do each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions, touching your service and qualifications as a juror, so help you God? Please say, "I do." Okay, you may put your hands down. Now, the law requires that each of you must possess certain qualifications before you may be considered for service as a juror. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if all of you possess the qualifications for service on a criminal jury. It is very important that you answer these questions truthfully. Now, if you do not, and the lawyers or I discover this fact, this case will be retried and you could be held in contempt of court. That is, you could be placed in the Jefferson County Jail and be given placed in the Jefferson County Jail for 180 days, and you could be given a fine that does not exceed $500. Now, the way I'm going to ask the questions, I will ask a series of questions. I do not want you to answer those questions out aloud. I just simply want you to answer the question to yourself. And then once I ask the last question, I will then ask, is anyone disqualified under the law? Now, if you think you may be disqualified under the law, I would ask that you raise your hand. And once you raise your hand, we'll ask that you will come up before the bench so that we could discuss the matter more privately. Now, when I'm using the term more privately, what I'm talking about is we're currently on YouTube. So I'm gonna turn off the YouTube. I will turn off the microphone, and then I will put on this noise sound device. And then we will discuss this matter on this side of the bench because this is where our court reporter is. And so he'll be able to hear everything that is being said. Okay, so again, I will ask a series of questions. I do not want you to answer those questions out aloud. Just answer it to yourself. And when I ask the final question, is anyone disqualified under the law? If you think that you may be disqualified under the law, I would ask that you raise your hand. Okay, first question. Except for failure to register, are you a qualified voter in Jefferson County in the state of Texas under the Constitution and laws of the state of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, I usually pause before I ask this next question because I need you to understand that I'm required to ask this question by law. I'm not trying to pry into your own personal affairs. And the question is as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petty juror for 6 days in the preceding 3 months in a county court or 6 days in the preceding 6 months in a district court? That was the last question. Now, is anyone disqualified under the law? If you think you may be disqualified, please raise your right hand. Let the record reflect that no one on the panel raised their right hand. So at this time, all the members of the panel qualify. Now, I will proceed to exemptions. I will determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, just remain seated. Now, I will ask these questions in the same manner that I asked the previous series of questions. Please answer these questions to yourself. And then once I finish asking the last question, I will then ask if there's anyone who would like to claim an exemption. First question. Are you over 75 years of age? Do you have legal custody of a child or children under the age of 12 years and jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled in an actual attendance in an institution of higher education? Are you an officer, employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in Jefferson County during the 3 years preceding today's date? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? And this is the last question. Are you a member of the United States military forces serving on active duty and deployed away from your home station, which is Jefferson County, and out of your county of residence, which is Jefferson County? Now, is there anyone on the panel who would like to claim an exemption? Okay, let the record reflect that no one on the panel is claiming an exemption. Now, I will move to excuses. Now, with the excuses, I will not ask a series of questions. I will make 3 statements. And if you would like to claim an excuse based on any one of these 3 statements, just raise your hand when I ask if there's anyone who would like to claim an excuse. First statement. A juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may be excused for a juror may not be excused for economic reasons without the consent of the parties. That is, without the consent of the state of Texas and without the consent of the defense. Last question, or last statement rather. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who would like to claim one of the previous mentioned excuses? Let the record reflect that no one on the panel is claiming an excuse, no one is claiming an exemption, no one, and all the members of the panel is qualified at this time. Let the record reflect that the time now is 3:31 p.m. on today's date, on March 16 of 2026. Let the record reflect that the defendant's counsel, the state's counsels, and all members of the panel are present. Now, again, members of the panel, you have been summoned to this court as a prospective juror in a criminal case. And as I mentioned to you earlier, it is a misdemeanor criminal case. The defendant in this case is Kenya M. Coleman, and she's sitting at the desk at the table with her attorney Ralph Kimler. The state is represented in this case by Assistant Criminal District Attorneys, Attorney Cornelius Williams, and Attorney Farrah Nixon.
Good afternoon, everyone, and welcome.
Our court reporter is Mr. Sebastian Aguilar. He's sitting to my left. He will be taking down everything that's being said, so speak up when you are answering or asking questions. The bailiff is Ms. Brenda Mosby. I think you met her earlier. She is the bailiff in County Court at Law number 2. The defendant staying charged by information with the offense of assault bodily injury. This is a Class A misdemeanor, and as I mentioned to you earlier, the range of punishment for a Class A misdemeanor is 0 days to a maximum of 365 days in the county jail, or a fine that does not exceed $4,000, or she could be given both such fine and confinement. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come up to the bench so that we may discuss it more privately. Is the state ready to proceed?
State's ready, Your Honor.
Is the defendant ready to proceed?
We're ready, Your Honor.
Okay, Mr. Williams, how much time do you need?
I'd like to have 25 minutes.
Okay. Okay, Mr. Williams, the panel is yours,
Thank
and I'll keep time.
Once again, good afternoon, everyone, and welcome and thank you all for participating within this wonderful thing that we call the criminal justice system. During our time here today, we will ask only a few questions that will definitely pry. But here we are, let's get us down a few guidelines and rules that we all will follow. Again, this is WADAR, and it's a French term, means to seek the truth. You've already taken an oath, and there aren't any right or wrong answers, but all that we ask is that you all share your answers truthfully. It is important to note here that if there's something, if I ask a question that you feel again uncomfortable with, we'll just note that. You'll let us know, then we will be able to address that by going, up to the bench, and we'll talk about it as the judge mentioned, where he will put in like the white noise, and we'll discuss it further at the bench. If there's anything that I ask where you're uncomfortable with the answering. Once again, there aren't any right or wrong answers that you guys can give. Now, this is a case that involves an assault. Assault is defined by the Texas Penal Code as a person who commits an offense if they intentionally, knowingly, or recklessly causes bodily injury to another, including a person's spouse. We'll come back to that. Now, what is bodily injury? We can think of bodily injury as any type of harm. Ouch, that hurt. We can have either their punches, their kicks, their bites. All that you guys would have to do is while we go through this process, there isn't anything supernatural or hard about this, but we apply our common experiences and our common sense as we determine bodily injury. It is defined once again in the code by any physical pain or illness or impairment of a physical condition. Now, even if there aren't any photographs or marks or something else, can we all agree that if a person is struck and that person feels pain, that that would be an injury? Does anyone disagree with that statement? We have to talk about the mental state. In order to commit an assault, it is not by accident, right? A person have to do something, okay? And how does a person do something? They may do it by wishing for something to happen and doing an action. What is that? A conscious objective and design the result. If a person strikes another person, did they do it by accident? If by accident, then that wouldn't be an assault. If it's knowingly, intentionally, or recklessly, then that person did it again with the intent, and that meets the what we call the mens rea, the culpable mental state. So we're not talking about accidentally causing any injuries. We are speaking of a person actually wanting the desired outcome. Basically, does the person do it on purpose? You will see evidence in the case, and what we will present to you all, there's two kinds of evidence. One is direct evidence. Direct evidence is when a person, I saw it, I was there, this is what happened. No one has a problem with direct evidence, but let me put it before you all right now. The evidence will come from the witness stand. okay? That's where all the evidence, comes from within a case. And the way in which you will factor the evidence, and while we're going through this process, are there any biases or any prejudices? We bring our common experiences to these elements, to these offenses, but we apply those. That's the filter that we use. That's all that we ask that you use when you're looking at the evidence. So when a person takes the stand or when you see physical evidence, could be pictures, it could be statements. But when you look through those statements, we judge the person who's giving the direct evidence. Was the person there? How did the person, perceive what may have occurred or what did occur on a particular date and time? There's also a second kind of evidence, is circumstantial evidence. And I'm going to go on and submit to you all right now. The state believes the law states that you must treat direct evidence and circumstantial evidence exactly the same. Here we go with a picture of Rocco. Somehow we left him at home, he gets out of the cage. What does Rocco do? You come home and you see things thrown about. He got like into the trash. Now, we have to look at direct evidence, the state's proof, and circumstantial evidence, the same. Now, beyond a reasonable doubt, can anyone, beyond a reasonable doubt, if you come home, Rocco has the trash thrown about everywhere. Nobody else was in the home, only Rocco. Could you treat Rocco's circumstantial evidence the same if you saw Rocco tearing up everything? Can we all agree that we will apply the circumstantial evidence and direct evidence the same? Does anyone disagree or respect more? Once again, in this case, we have the burden of proof to prove beyond a reasonable doubt. What is a reasonable doubt? Well, once we're going back to Rocco, if someone were to say, well, an alien could have came down and destroyed everything, okay, of course, maybe so, but is that reasonable given the fact that you know the circumstances in which you have left Rocco at home? It's not beyond all possible doubt. It's not beyond that. It is beyond a reasonable doubt. In some cases where you would have a civil case, and I saw some of you served on the civil jury, it's a different burden of proof. In a civil case, it's by preponderance of evidence, slightly tipping the scale one way or slightly tipping the other. When it comes to child protective cases and things, it is by clear and convincing evidence. But when it comes to a criminal matter, it is beyond a reasonable doubt, not all doubt. And we submit, once you apply that filter of the common experiences, of the common sense, where evidence that will come from the stand, reasonable doubt can be shown. While the state will overcome, again, the reasonable doubt, it's important to note that the defendant has absolutely nothing to prove. It is the state's burden, and Farrah and I, we represent the state of Texas in the matter should you be chosen to sit in this matter. And the state of Texas is made up of who? It is made up of the people. It is made up of you all. It is made up of the members of the community. And that person who sits before you, the school has the absolute right and the presumption to hold us to that burden of proof, which is beyond a reasonable doubt. Now, we're going to touch on what is reasonable doubt versus all doubt. I submit to you, because the court will not give you a definition of what is reasonable doubt, I will submit to you all that when you're making a decision, could be buying a home, right? When we buy a home, we use due diligence, we apply common experience, And when we decide to buy that home, it's not beyond our doubt. We don't know certain things, but beyond a reasonable doubt is when we make that decision. Now, here's one for you all. How many of us drove here today? How many of us drive? And we all drive. Now, how many of us stop on a green light? Stop on a green light. We do know when we have our prized possessions in a car, or even if we're driving by ourselves. We know, and we've heard of, and we've had experiences of horrible car crashes, right? Where somebody will blow right through a red light. And blowing right through the red light, you can get T-bone, you have the green light, but do we stop at every single green light because some yahoo may be barreling down the roadway? No. The reason why I bring that up, that I'll submit to you. If we had reasonable doubt that a car will run that red light, we will all stop at a green light. But again, in our common experiences, what we do day in, day out, this is how we apply what's beyond a reasonable doubt. Chances are, when I see a green light beyond a reasonable doubt, an 18-wheeler is not going to be barreling down on. Is it possible? Of course. But again, I'm trying to stress that it is not beyond, again, all doubt. It's beyond a reasonable doubt. And we apply that each and every day in the decisions that we have possible witnesses within this case who we think that may testify. First of all, does anyone know Ms. Kenya Coleman, the defendant in the case? Does anyone know her? For the record, no hands were raised. Does anyone know Mr. Rice Kimler? We have one that knows Mr. Kimler, and that would be Ms. Mayfield. This Ms. Mayfield. And how do you know Mr. Kimler?
Probation, court.
And by knowing Mr. Kimler and by you being a probation officer, would that affect your judgment in the case, or can you be fair and impartial to the defense as well as the state? And by you being a probation officer, will you look at the testimony which will come from the stand any differently by given your position in law enforcement? Thank you. Anyone knows May Cornelius Williams? No, and Farron Nixon. Record fact, no one knows any of the other counsels in the case, nor the defendant. Now, we believe that there will be testimony from the following witnesses, not all of them, but some of them. Ms. Diamond Davis will be the complainant in this case. She lives out in China. Anyone know Ms. Diamond Davis? Does anyone know Mr. Kelly King? I'm sorry, Ms. Diamond Davis? Live out in China, and you are Ms. Durso? Okay. How do you know Ms. Davis?
I just know her. I didn't make friends with her usually, but you know how people growing up,
Yes,
right?
ma'am.
Like going to high school. She was on the best.
Now, by you knowing Ms. Davis, could you listen to her testimony without being biased toward her or prejudiced against her? Could you just listen to her testimony? Just because you not know her, you would not find her testimony to be, what is the word? I'm so sorry. So you can just listen to her testimony and be fair to both sides, correct? Does anyone know Mr. Kelvin King? Now, Mr. Kelvin King lives over there off of Willow Bend. Does anyone live in the 8400 block of the Willow Bend area? Or does anyone know Kelvin King? No response. Continuing, How about Miss Jean Boucher? Miss Jean Boucher. She lives over in the 8200 block of Willow Bend as well. We have members of the Beaumont Police Department, Detective Sergeant Yvette Barrero. She's oversigned to the assault unit. Anyone knows Detective Sergeant Barrero? Police Officer Lamb. Police Officer Trahan, or Duvel. Now, couple things that I'd like to, just to touch on. Obviously, this case involves, physical violence. Does any member of the array have been either a victim of an assault or had a close family member or relative that has been a victim of an assault? We're not seeing any hands, I'm sorry, yes, ma'am. Juror number, Ms. Smith?
Yes.
Yes, ma'am, is that something that, you can tell the panel, or would you like to approach on?
I had a nephew assaulted.
Has anyone had, thank you very much. Let me follow up on that. I'm sorry, Ms. Smith. By your nephew being a victim of an assault, will you be able to set that aside, listen to the evidence as it's presented here, and be fair to both the defense and the state?
Yes.
Has anyone had a close member, a family member, or a close friend that has been charged as a defendant, has been charged with an assault case? Final, two final matters I want to go over. As any member of the panel had a difficult, I'm being careful, I won't get to the particular facts of the case. Had any member of the panel been involved in a contentious or violent breakup at the end of a relationship? Final matter I have to discuss. We believe that this case probably will last until, I'll be candid, my guess is probably until Thursday. If anyone will not be available Tuesday afternoon, so say from 2 to 5, Wednesday afternoon from 2 to 5, or Thursday afternoon from roughly 2 to 5. Yes, ma'am. That would be Ms. Perez.
Mr.
What do you have, Ms. Perez?
I have an OBGYN appointment on, Wednesday and endocrinologist appointment on Thursday. They both lie at like 3:00.
Thank you, Ms. Perez. Anyone else? Ms. Bover, I have to ask you, you have a, is it a Bover?
Yes,
Bover?
yes,
Was that a 13-year-old?
I do 13-year-old.
Okay. That's 6th grade or 7th?
He's in 8th grade.
Oh, 8th grade. Oh,
Yeah.
the precocious one.
Yeah.
Will there be any issues with you, sir, like for doing that time?
No, sir, his father's at home with him.
One moment, please. We're tender to the panel, you know. Okay,
Mr. Kimler? Down is yours.
Good, something great. Afternoon, I'm gonna try to move a little bit quicker, maybe here in a while. We have to ask those questions because it's not so much a process of selection, but deselection. Each side gets to eliminate 3 people off the panel. First 6 that were left would constitute the jury, so really not looking for people as far as, you know, from my perspective, that for whatever reason would be perhaps good drawers in the stock case, in the salt case. The 6 people who have been maybe perhaps victims of assault might not be able to be fair and impartial or something like that. And, you know, it wouldn't mean they're just a bad drawer in other cases. Just some reason, you know, for whatever reason, that just, you know, particularly suited for this type of jury. They've done a lot with DWIs, try a lot of DWI cases, you got people that have had family. They've been injured or getting killed by intoxicated drivers, so a lot of times they aren't necessarily very sympathetic for the defense of those type of cases. So it just depends on the type of case that you're trying, what kind of particular people, you know, that, you know, may be suited for that jury or not suited. So anyway, that's what's going on. I don't think any of you identified yourselves other than this, Smith, I guess, either a victim of assault or something like that. Anything about that experience that you think would call into question your ability to be fair and impartial in the case or not?
No.
Bid both sides a fair hearing, right? Did you think when you walked in here and you saw Ms. Coleman sitting at that table that she'd done something wrong to be in here today, to be charged with a criminal offense?
No.
Anybody think that? No, you know, the fact that somebody's accused of a criminal offense, that they've done something wrong with being accused. Anybody, Mr. Mudd, what do you think?
No.
What's an accusation?
Excuse me?
What does the accusation mean? It gets the case rolling, gets us into court, the stage we're at now, to select people to serve on a jury to hear evidence. What evidentiary weight does the accusation have?
Well, I'd have to hear to see.
Yeah.
If it's true.
Just an accusation, right? Doesn't carry any weight. So it's an accusation, and it's up to Mr. Williams of the state of Texas to bring forth convincing evidence to show you, demonstrate to you beyond a reasonable doubt, eliminate every reasonable doubt you may have about whether this particular person did the particular things that the state's alleging, right? Why do we have juries do that, Mr. Tate? Why do we have juries to say that? Why can't we just let judges do it?
I just want to be here. I've always told people, a lot of people always say, why do you do this? I say, the reason I do it, if I'm ever that innocent person, I want somebody good like me to be up there.
Right.
I don't want that guy wanting that $6 just to be up here and look how make.
Well, what, you just go further than that, why not just let judges decide it instead of people from the community? Well, why not let people, maybe we can get Judge Holmes and get Judge Woods and maybe Judge Stevens and have them listen to evidence and decide whether or not to convict somebody.
I think it'd be more biased if they'd be just one person instead of multi-type people.
What's the result of a conviction? What's the consequences of a criminal conviction?
Sir?
What's the consequences of a criminal conviction? You heard Judge Holmes tell you the penalty ranges of the different offenses. What's the consequences of somebody getting convicted? Of a jury finding them guilty, what's the consequences of that?
I really don't know.
Anybody, what's the consequences of being found guilty? Punishment, right?
Yeah.
Punishment. Who in our system gets to decide whether somebody's gonna be punished? The jury, juries, right? The jury makes that decision. That power rests with the people. And irrespective of whatever else happens to this country, that jury system is still in place. That's there, that's bedrock. So before somebody can be sent off to the penitentiary and deprived of their freedom, they still have to have a jury find them guilty. That's fundamental. That's not going to change. They try to chip away at it or whatever else, but that's always going to be in place. It's a fundamental principle of the way things are done in our country. So that's the reason I would take it seriously if I were on the jury and evaluating the state's evidence, because you're not gonna get an instruction from Judge Holmes about what proof beyond a reasonable doubt is. The law comes from Judge Holmes. I know, Mr. Williams has talked to you a little bit about what the law is. What he says the law is, when I say the law is, that doesn't control. We're the lawyers, we're advocates. The law that controls in the case comes from Judge Holmes. In the case, he's gonna give you a written document, it's gonna contain all the law necessary for you to decide the case. It's called the court's charge. It's not gonna contain a definition of proof beyond a reasonable doubt, really the most important concept in the case. And he'll tell you that it's not proof beyond all possible doubt, but he'll leave it open to each of you who are on the jury to set that standard for yourself, what exactly it is. I would simply suggest to you that to give it proper context, that the consequences of finding that the state's met their burden of proof beyond a reasonable doubt is punishment. So if you're thinking about, well, how high the standard that is, or how high the burden of proof is that I hold the state to, well, it's somebody's freedom is what we're talking about potentially. And it's not an impossible burden. Obviously, there are many people who are convicted with that standard every day throughout the state and other states. But I would argue to you, because of the consequences, the consequences, the potential consequences of the punishment sort of contextualize or frame how high of a standard that should be. Do you agree with that, Ms. Serval? You agree with that? Ms. Smith, you agree with that?
Yeah.
Ms. Broussard, what do you think? Think that's fair to Mr. Williams and the state?
Sorry,
You think that's fair to Mr. Williams and the state of Texas? That's,
I think that you both have to present both sides and we have to make it
okay.
based off what you present, we have to.
Well, you say both sides, do you expect the defense to put on any evidence at all?
No, and I don't know if it's gonna be a situation where, like, they would have to take a stand, but I know that the state has to present their side.
Right. You say both sides is why I asked.
Yeah,
If you voted right now, what would your vote be? Guilty or not guilty?
I can.
What is-
Everybody thinks.
Well, what is- what would your vote be?
That makes sense.
I'm sorry,
If they have the burden of proof of beyond a reasonable doubt, and you haven't heard any evidence that suggests that they met that burden of proof, what would your vote be right now?
I couldn't.
Think
say-
hard, think, what would it be? You haven't heard any evidence at all, and it's their burden, so what would it be, guilty or not guilty?
I couldn't say, I don't have anything, I would say not guilty, I couldn't.
All right.
Yeah.
You see that? It's not a trick question. What would your vote, what would the vote be right now?
Not guilty.
Not guilty? Right. What's the presumption right now? Your heart hears this every on TV anytime.
Still proven guilty.
For presumption is innocence, right? The presumption is innocence. Do you know that that's presumption of legal innocence, right? The presumption is somebody's legally innocent. Does that mean a person factually is innocent? Certain, no, just saying in the legal system, they're presumed to be innocent. So the jury's find people innocent, Dursa? Yes, ma'am. The jury's find people innocent?
Juries find people innocent.
Yes, ma'am.
Yeah.
How many people agree with Dursa? The jury's find people innocent? Ms. Bouvier?
They found them innocent after listening to.
Okay.
After listening to her.
How many people think juries find people innocent? Show on hand, are you right? You got one, who else? Who disagrees? Yeah, all right, what do you say, Mr. Let me find you on the list here.
Holt.
Oh, Kim Rowe,
Kim.
Kim, okay,
Juries don't find people innocent. What they do is they decide if the burden of proof has been met. And
Right.
if it has been met, then they find them guilty. Otherwise, they're not guilty.
so it's not guilty the same as innocent?
Not guilty is just not guilty.
Not guilty is not guilty, not guilty doesn't mean the person's innocent, right?
Correct.
Actually, innocent. So juries don't find people innocent. Innocent is one of those certainties, right? Absolutely sure they didn't do it, the state said they didn't know it, it's certain they're innocent. They're presuming, there's a presumption that they are, but that's not saying they actually are, that's why it's a presumption. So presumptions are. All right, so what about if you convict somebody if they're guilty? Does that mean that they actually did what the state said that they did, factual certainty?
It means that beyond a reasonable doubt, which to us would mean that I guess, and that, I guess presume that they have met that burden of proof. We can't tell if they are guilty or they are innocent. We can just say they met or did not meet the proof.
What we would say, I think the word is fancy, epistemic certainty, right? Epistemic, any of those study philosophy, I don't know, epistemic certainty, actually did what the state said they did from a factual standpoint. Is that what a guilty verdict is? Certainty? Just, are people have people been convicted beyond a reasonable doubt that it turns out later on they actually were, right? How do you know that?
Because unless I was there and actually saw, witnessed, or felt the event, then I can't tell you if you're guilty or innocent. I can just tell you if you presented something that made me think.
No, you can't tell if they actually did
If
it
they
or,
did.
or
That is correct.
the two polarities of certainty, right? How do we know that there are people who've been convicted who actually were factually innocent? DNA, right?
Yeah.
Great.
We've seen.
The great enlightening factor makes you think that before DNA we were using leeches and amputating with a saw without anesthesia with legal system without DNA. Right, DNA is exonerating many people who have been convicted beyond a reasonable doubt, and that's not the fault of the juries. They did the best they could with what they had. But the point is, on either end of what the juries do in the criminal justice system, you're not able to certainty. You're just doing the best that you can with what you have. And legal guilt and not guilt are legal concepts. They're not factual certainty. We're not talking about factual certainty. And then I get back to the burden of proof and how sure that you want to be before you convict. And so I'll go back to Mr. Value. What do you think? Proof beyond a reasonable doubt, how high the standard is that? Because of the potential consequences. All right, what do you think, Mr. Wood? Proof beyond a reasonable doubt? High standard. You got, Mr. Alfred, what do you think?
Yeah.
Ms. Mayfield? Right? Deal with a lot of people on probation, a lot of people pled guilty, convicted, got probation, right? Standards met all the time, either through a plea or a trial, right? It's not impossible. It's Bouvier, I keep calling it Bouvier, I don't know if that's right. Bover, absolutely.
Yes,
What do you think, proof beyond reasonable doubt?
absolutely.
Absolutely. Ms. Holmes,
I'm sorry, can you ask the question?
what is your concept of proof beyond reasonable doubt? How high of a standard is that, or how difficult of a burden should it be to the state, and is it fair to the state?
Yeah, I think it's a high standard, and I think it's one of those things that, you know, that we see it, you can't really determine it ahead of time, what if you're on, how do we?
You know it when you see it? Is that what
When
you-
you hear it,
when you
you know,
hear
it's not. I can't give you now.
So in other words, you would know whether the standards is met once you hear the evidence in your own mind, and you would, well, perhaps able to articulate the exact standard of what proof beyond a reasonable doubt is, but you would intuit it maybe. Know it, believe it, maybe, might be the element, the realm of belief instead of knowledge, I suppose, I don't know. Believe it or knowledge, because they don't say no beyond a reasonable doubt, right, it's believe you. Yeah.
But without having some sort of fact, just instantiate it right now, I can't tell you what
How
I
do
would
you-
say is beyond reasonable doubt,
How do you determine the fact? What is testimony?
based on the testimony.
How do you evaluate the credibility of what somebody's saying from the witness stand, whether they're telling you the truth or not, when they're trying to infer facts from testimony?
Based on how it's written.
Based on how would you determine that, make that determination with an individual? If they're telling you the truth, evaluate the credibility, because I anticipate Judge Holmes is gonna instruct you that as a juror, you're the sole judge of the credibility of a witness, of a particular witness, that you can believe all part or none of whatever the witness tells you. How would you make that determination as far as credibility of a witness? What are some of the things you would rely on?
I would rely on what y'all as the attorneys are saying, what they're saying, how they're saying it, their stories stay consistent.
But is it consistent? Is it consistent with the proven facts, perhaps, that kind of thing?
It could be with the proven facts, or do they contradict themselves with their own.
Anybody else have any ideas about valuing the credibility of witnesses? How you would do it? Any ideas? No? Because as jurors, you have to evaluate credibility of the witnesses to infer facts, right? Whether somebody's telling the truth to infer facts that you need to decide the case. Okay, thank you. Not related to the lead office, right, by chance? Lead office? No, okay. Person I knew a long time ago. It's done, what do you think? Put down those without. You can follow your own conscience and make the right decision. All right,
The clarification, the teacher and coach. While I've seen some conflicts broken up. Like,
Okay.
Like, so you go by, what you train, what, how people present it. And I guess, how they represent themselves.
Right.
I think that,
I think Mr. Williams, I don't do PowerPoint, I barely do computers, but. I don't have a PowerPoint. There's a funny story, I had a client that got so mad at me during closing argument one time about not having a PowerPoint, I had to call timeout. But anyway, I don't have a PowerPoint. But remember the dog, right, Mr. Williams' PowerPoint? Dog's sitting there, and he's making the middle, of everything's all kind of torn up. And he's looking, he looks kind of guilty, so you can infer, oh, well, what circumstantial evidence the dog tore everything up, right? Like, well, I mean, maybe there's another dog, I don't know, maybe is that the only dog, what other questions do you have? There's things that could be misleading from circumstantial. I'll represent to you, maybe when I was about 9 years old, my mother and I were visiting out her sister and her kid out in Florida, her daughter, my cousin that didn't particularly get along with my age. And my cousin and I got in an argument, well, she bit herself. Right? And they goes running in to my mom and her sister crying that I did it. And of course, they're not taking measurements of the butt to compare. So guess who got whipped over that? So you got a bite mark, you got somebody testifying about it, the cousin. You make the inference, you jump, and then bam, you reach your conclusion. So that's the problem with circumstantial evidence sometimes. You may need to dig a little bit deeper, make deeper comparisons and listen to the cross-examination before you are willing to give it that level of certainty necessary to base a conviction on. That's what I'm saying. Mr. Let's see. Troy, is that right? What do you think? Proof beyond reasonable doubt.
Seems to be the most logical way to approach the situation, so.
Okay. You hold the state to a high burden?
Yes.
This, Durso, what do you think? Okay. Excuse Perez, what do you think, Mr. Perez? Mr. Holt, what do you think?
I agree that it's especially considering the consequences, you have to hold them to a verdict.
Ms. James? Pilgrim, will add anything? And Ms. Pearson, what do you think?
And then possibly take away somebody's freedom, you gotta make sure it's worth it. I mean, you gotta make sure that.
If it's justified. Okay. All right, any other questions for me? No, okay, I believe that's all I have. Thank you.
Okay, ladies and gentlemen of the jury, we're gonna ask that you go outside in the hallway and we may call one or more of you back in for some follow-up questions. So at this time, the court will be in recess. Everyone, please stand as the panel exit to jury. The courtroom. Court is in recess.
You go to
Remember the time you sent the alternate back to deliver?
Yeah,
And it was still not guilty?
yeah.
I'm serious.
I know, back in our last.
Yeah, yeah.
Back to you.
Long as the person went before person.
Yeah,
Long as the person went before person.
right.
You looked it up? Yeah. I know what you looked, you did the research.
Okay, y'all may be seated. Jefferson County Court at Law number 2 is back in session. The court is in session in cause number 24 CCCR 2277. Case is style of state of Texas versus Kenya M. Coleman. Let the record reflect that Ms. Coleman is present in court with her attorney, Attorney Ralph Kimler. Let the record reflect that the state is present with Assistant Criminal District Attorneys, Attorney Cornelius Williams, and Attorney Farrah Nixon. Let the record also reflect that the panel is now seated and present in the courtroom. State, are you ready?
State's ready, Your Honor.
Defense, are you ready?
We're ready, Your Honor.
Okay. Ladies and gentlemen of the panel, when your name is called, please, and you're gonna go and have a seat in the jury box. On the counter of the jury box, there are some badges. Please take one badge, and when you get into the jury box, you can pin it on your clothing. At this time, we have Ms. Trina Redmond, who is one of our court coordinators. She will call the names of the individuals who will be seated in the jury box. Ms. Redmond,
Donald Tate,
Donald Tate,
Christina Saravolo. You know, you can do whatever you want to grab that, right here. Just take. You grab one of those jewels. Bridget Smith. Stephanie Broussard. Lori Durso. James Valier. Andrea Bover.
members of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to the particular case. The facts come from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and court decisions interpreting them and how they may apply to this case. You and I have equal authority, but it is divided authority. You are the sole judges of the facts, and I'm the sole judge of the law. You are the sole judges of the credibility of the witnesses and the weight to be given their testimony. You may believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorney of witnesses or objections to the introduction of documents or objects. This means that in the objecting attorney's opinion, there is a legal reason why the testimony or document or object should not be received by you. Sometimes I will simply sustain or overrule the objection. At other times, it may require lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you can't hear the discussion on the point of law. The reason for that, as I told you earlier, you are the sole judges of the facts you receive, and I am the sole judge of the law. I can't be with you in the jury room when you deliberate the facts. Therefore, you can't be present or within hearing when I deliberate questions of the law. The reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather his equipment and take it with him, and the attorneys would have to gather their files, etc. Now, the rulings that I do make on questions of law in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both the state and the defendant have rested their cases, the court will prepare and submit to you a written charge instructing you on the law in this case. We would then hear oral arguments from the attorneys. The attorneys have the right to make a summation of the evidence and to make reasonable deductions from the evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument. Until you retire to deliberate, do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any source outside of the courtroom anything about the facts of this case, nor attempt any independent investigation on your own. Don't visit the scene involved in the facts of the case. Don't read any reports in the newspaper, on television, or watch television, or even read any reports on social media. Do not make up your mind about this case until all the evidence is in and you have been instructed on the law. Don't take notes during the progress of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. The badges that you have, please wear those badges at all times. Those badges identify you as a juror in this case. You'll be allowed to take those badges home with you. Now, ladies and gentlemen of the panel, those of you who was not selected, first of all, on behalf of the citizens of Jefferson County, behalf of the staff here in County Court at Law Number 2 of Jefferson County, Texas, I'd like to thank you for taking time out from your busy schedules to be here this afternoon. I know that you were eager to be selected as a juror on this case, and you may be disappointed because you might think that, I came up here, sit here just about 3 hours, 4 hours, and I was not selected. I wasted my time. Guess what? you did not waste your time. And the reason why I say you did not waste your time is because, as I mentioned to you earlier, this court had 3 dockets today. And one of those dockets was a trial docket, which we had several cases. This was not the only case on the trial docket. And I know why when you sat out there, you probably saw people coming in and out of the courtroom. That's because cases was being handled in this courtroom. And it was because of people like you who took time out from your busy schedule, those cases was disposed. And I'll just explain to you, sometimes, well, the state and the defense usually get together. The state make an offer to settle the case. And sometimes some individuals may say, you know what, I don't want that offer because I believe on this date, when I have a trial, one or two things are going to happen. One, the witness is not going to show up. 2, the jury is not going to show up. So I'm not going to take that off. But on days like today, when witnesses show up and when jurors show up, it is not uncommon for some people to have a change of heart. That is, they say, you know what? That offer that the state made to me a few months ago, it looks pretty good right now. Okay? And so what I'm saying to you, members of the panel, your presence helped us to move several cases today. And it's because of people like you who take time out from your busy schedules to come down here and participate in our jury system. We cannot move a case without jurors. Okay? And when I'm talking about in a trial, the person that has a right to a jury trial, we can't move it without jury. They want a jury trial. So when you show up, we're able to move cases. Now, I know that when you came down here this afternoon, probably some of you were sitting outside, you looked over the top of the door and you said, this is County Court at Law number 2. I'm in the right place. This is Judge Holmes' court. But guess what? This is not Judge Holmes' court. This is your court. This court is for the citizens of Jefferson County. I'm only humble public servant serving the citizens of Jefferson County. I've said that to say this. Anytime that you're in the area of County Court at Law number 2, you can come have a seat in your courtroom. That area that you sit in, we call that the peanut gallery. But you can't bring peanuts in here and eat because this is not the Texas Roadhouse. But you can come and see what goes on in Jefferson County, and I can assure you, you'll find it very interesting. Now, if you cannot make it down to County Court at Law number 2, guess what? You can watch us on YouTube, and you can see what goes on in County Court at Law number 2. So on behalf, again, of the citizens of Jefferson County, behalf of the staff here in County Court at Law number 2, I'd like to thank you for taking time off from your busy schedule. Now, you met our bailiff, Ms. Mosby. She has some letters for each person. She's going to give you a letter if you need an excuse. Now, the district clerk's office is, they usually close at 4:30. And so if you need an excuse, just let us know and our staff will be happy to prepare for you an excuse. At this time, before you excuse, I usually tell people, I like to give everyone a handshake. We still have COVID in our communities. People are still getting sick. But however, I like to give each and every one of you what I call an air handshake. So on behalf of the citizens of Jefferson County, thank you for coming out this afternoon. And each and every one of you have a blessed day. You're excused. All right, Fred. You can go out either door.
So this gets good for the guy?
No, she can prepare one, please. Okay, now, ladies and gentlemen of the panel, we'll be in recess for this afternoon. And we're gonna ask that each and every one of you be back on tomorrow at 1:30. You're gonna sit out in the hall. And when the bailiff is ready, the bailiff is gonna come out and get you. Okay, so you're excused for the eating. You can take the badges with you. Everyone, please stand as the panel exits the jury, well, the courtroom. All right, y'all have a blessed day. Court will be in recess.
Be back at 1:50.